This is your jury charge performance challenge for week 6. Paragraph. Members of the jury, now that you have been sworn, I will give you some instructions as to the law that will help you as you hear this case, period. At the end of the trial, I will be giving you more instructions, and it may be that I will also give you some instructions during the trial, period. That is my job, period. Paragraph. By the oath that you took, you must follow the law as I give it to you, whether you agree with it or not, period. You must also perform your duties as jurors, regardless of any personal things you may feel about this case, period. That means that you must decide this case only on the evidence that will be given to you here in this courtroom, period, paragraph. In the following instructions that I give you, you must follow all of them and not single out some and ignore the ones you do not like, period. All of these instructions that I will give to you are very important, period, paragraph. You must not read into these instructions or into anything that I may say in this courtroom as an indication from me that I have any opinion as to what the verdict will be, period. That is your job as jurors, period, paragraph. Deciding questions of fact is your exclusive responsibility, period. In doing so, you must consider all of the evidence that you will hear and see in this trial, period. If you see or hear anything from any other source, you must disregard it right away, period, paragraph. The attorneys who will stand before you are officers of the court, period. It is their duty to present evidence on behalf of their clients and to make such objections as they deem proper and to fully argue their client's side of the case, period. Please remember that the arguments or remarks of either attorney is not to be considered as evidence at any time in this trial, period, paragraph. If the attorneys or I make some statement as to what the evidence is, and it differs from the evidence as you have heard it, then you should disregard what any of us has said and rely upon your own memory, period. If what the attorneys may say to you differs in any way from the law that I give you, you must accept what I say about the law, period, paragraph. During the trial, I may be called upon to rule on objections to certain testimony and exhibits, period. You should not concern yourselves with the reasons for my rulings, since they are controlled by rules of law, period, paragraph. Objections that the lawyers make are not evidence, period. They have a duty toward their client to make objections when they think the evidence given does not help their client, period. If I sustain the objection that an attorney makes, comma, you must ignore the question, period. If I overrule the objection, comma, you must consider the answer to that question as evidence, period, paragraph. I will never put any weight upon the importance of any objection that I rule on, period. You must disregard all evidence that I have ordered stricken from the record, period, paragraph. A fact that may be proved by either direct or circumstantial evidence, comma, or by both, comma, and you should know that the law does not prefer one form of evidence over another, period. A fact is proved by direct evidence when, comma, for example, comma, it is proved by a witness who testifies to what he or she saw, comma, heard, comma, or experienced, comma, or by physical evidence of the fact itself, period, paragraph. A fact is proved by circumstantial evidence when the existence of that fact can be assumed from other facts that have been proven in the case, period. You will be the sole judges of when a witness is to be believed and of the weight that you should give to the testimony of that witness, period, paragraph. There are no hard or fast rules to help you in this respect, period. There are some things that you may consider when judging the credibility of the witness, period. Take into consideration their interest or lack of interest in the outcome of the case, semicolon, their relationship to the parties involved in the case, semicolon, their ability to know and remember the facts of the case, semicolon, their manner and demeanor, semicolon, their frankness and sincerity or the lack of it, semicolon, the reasonableness or unreasonableness of their testimony in light of all the other evidence in the case, semicolon, the fact that they may have been caught lying about the case, semicolon, and any other fact that you believe bears on the believability and weight, period. In the end, comma, it is your own good judgment and common sense on which you will rely, period, paragraph. Some witnesses will be allowed to express an opinion, period. These witnesses are called expert witnesses, period. There are several things that you must consider about any expert witness, period. You should look at the type of education and training that the person has, period. You should look at the reasons that they gave their opinion, period. You need to determine how they arrived at their opinion and what sources they used, period. You should determine the credibility of the expert witnesses just the same as you would any other witness, period. Their testimony is to be given no more or no less weight than the testimony of any other witness in the case, period, paragraph. Some testimony has come in the form of depositions, period. These are written statements made under oath that carry the same weight as the testimony of a person who is able to come into the courtroom and testify, period. It is your duty to judge the credibility of all testimony that is presented in this courtroom, either in person or by way of deposition, period, paragraph. I would like to talk with you about your conduct in this trial, period. First, you should not discuss the case among yourselves or with anyone else during the trial, period. At the end of the trial, we will give you as much time as you need to discuss the case among your fellow jurors, but that is at the end of the trial and not during the trial, period.